Difference between a power of attorney and a living will. A living will just states your wishes in black and white, whereas a power of attorney can do both. It can state your wishes in black and white, and then it appoints a second person that's actually going to make the decisions for you if you're incapable of making them. Yes, there are downsides to power of attorneys. When you set up a power of attorney, of course, you're putting one person in charge of your affairs. You have to be pretty certain that you can trust that person. If you can't, they are going to have control when you're at your weakest point, meaning you can't make those decisions for yourself. So there are risk rewards of power of attorneys. The benefit, of course, is once you appoint someone, there's no way under a living will that you can cover every possible situation that could come up with your medical care. Whereas with the healthcare power of attorney, that person can be flexible enough to know your wishes and make the decision for you.
Good.
When someone calls up and is wondering what a trust is actually a standalone entity that is subject to the trust document, meaning your assets go into a separate person from you, and that person is under the control of a trustee. The trustee makes decisions regarding the assets you've transferred into the trust. Now there's two types of trusts. There's a revocable and there's an irrevocable. Obviously the revocable means while you're alive, the grantor, the person that's transferring the assets in, can terminate that trust at any time while they're alive and competent. The irrevocable trust is an actual trust that once set up can no longer be changed, amended, except under state law. These types of trusts actually pass control of those assets when established. When we're looking at what type of estate planning document fits each person, we'll discuss with them, are you comfortable with your assets being managed by a third party or by yourself where you have to write out a check from a trust, meaning all your assets are no longer actually in your name, including your house, your bank accounts, your investment assets, other than your 401k, which will stay outside the trust normal case. The benefit then of having these trusts is you're not going to probate your estate, which means you're going to save from third parties looking at your assets, the values. You're also going to save on timing as far as going through the court system and reporting. The downside sometimes we see is if you don't pick the right trustee, you don't have the protections of a court overseeing accountings and inventory. And that can also lead to some issues between the beneficiaries of the trust, meaning your children. A dynasty trust is a continuing trust, meaning that the trust is across generations. People set up dynasty trusts to help protect their wealth not only from third-party creditors, but also from their heirs making poor decisions in the future. We get a lot of calls about dynasty trusts here at Costello Porter because South Dakota is one of the leading jurisdictions on dynasty trusts in the nation. Also, the state of South Dakota recently has enacted some creditor protections for our dynasty trusts. We're now one of the leading jurisdictions in the United States on creditor protections. Of course, still a lot of high net worth individuals will explore offshore trusts also.